Is Ripple prepared for Torres' decision in the Remedies phase? Coinbase, the most prominent cryptocurrency exchange, has recently submitted a response to the court requesting permission to launch an interlocutory appeal with the Second Circuit. Of particular note is that Meta Lawman, an advocate for XRP, has recently expressed his opinions regarding the development, which has sparked conversations within the market as a whole. In a recent post on X, the attorney lauded the persuasive arguments presented by Coinbase. He also brought attention to the fact that this case can expedite the resolution of important problems regarding the authority of the SEC about digital assets. The XRP lawyer applauds the powerful arguments made by Coinbase Meta Lawman, praised the legal team representing Coinbase for the strong argument they presented in support of an interlocutory appeal. It was pointed out by him that the topic of whether or not digital assets that are traded on exchanges are securities will inevitably be brought before the Second Circuit Court of Appeals. On the other hand, the only things that are unpredictable are the timing and the particular cases that will exhibit the problem. In addition, he brought up the fact that applications for interlocutory appeals are only occasionally granted. The Coinbase case, on the other hand, appears to be particularly well suited for expedited transfer to the Second Circuit Court of Appeals due to the prominence of the issue and the compelling arguments that were provided. Furthermore, Meta Lawman stressed that the basic problem that is at stake is of tremendous significance to the whole Bitcoin sector. To give some background information, Coinbase Chief Legal Officer Paul Grewal recently announced and emphasized the significance of their request. He added that the purpose of their appeal is to ascertain whether or not the Securities and Exchange Commission has the authority to regulate transactions involving digital assets as investment contracts without any contractual foundation. Grewal also brought attention to the fact that even the Securities and Exchange Commission acknowledged the relevance of this problem in the Ripple case. The SEC noted the industry-wide significance of the issue, as well as the substantial grounds for difference between opinions. Grewal also noted that Coinbase has been consistent in its efforts to obtain clarity from the SEC. This was mentioned in addition to the previous point. While this was going on, the company addressed the SEC in good faith to negotiate a regulatory framework that would be feasible for crypto innovation in the United States. Nevertheless, according to Grewal, these efforts were greeted with opposition, shifting positions, and lawsuits from the Securities and Exchange Commissions. Regarding the future of cryptocurrency regulation and clarity with its request for an interlocutory appeal, Coinbase demonstrates its dedication to bringing clarity to the cryptocurrency and to fight back against what it considers to be an overreach on the part of the Securities and Exchange Commission. Additionally, Grewal underlined that this appeal is essential not only for Coinbase, but also for the entire cryptocurrency business, as well as the 52 million people in the United States who possess cryptocurrency. In addition, he mentioned that the House of Representatives has acknowledged the requirement for clear rules and that Coinbase is attempting to get a comparable level of transparency through the judicial system. Particularly noteworthy is the fact that Grewal said in his remarks that Coinbase is committed to following this matter through to its conclusion, regardless of the timing. In the meanwhile, he thinks that the future of the digital asset area must establish clear and workable crypto regulation, as well as to push back against overzealous. The determination of Coinbase is reflective of the demand for regulatory transparency and fairness that is prevalent throughout the sector. Given that Ethereum was recently designated as a commodity by the United States Securities and Exchange Commission, the attorney for XRP had already anticipated that Coinbase would submit a request for a rehearing. Concurrently, the relationship between Coinbase and XRP has also been the subject of discussion in recent times. This coincides with the announcement made by the top cryptocurrency exchange that it will be relisting the XRP token for users in New York on its platform. The United States Securities and Exchange Commission, as can Ripple Labs, have delivered their arguments in the remedies phase of the lawsuit initiated by the SEC about XRP. The disagreement centered on the decision to conceal some information on Ripple's financial results and the subsequent sales of XRP to institutional investors after the protest. During the remedies phase, the plaintiff, the defendant, and any third parties who are waiting for Judge Torres' final verdict, which is anticipated to come after the decision is made regarding the motion to seal. Experts in the XRP litigation say that the verdict could be rendered considerably sooner, most likely in the third quarter of 2024. A cryptocurrency bill and a lawsuit against Ripple, the Financial Innovation and Technology for the 21st Century Act 21 was put to a vote in the House of Representatives of the United States of America. This act represents the initial step in establishing a regulatory framework for the trading and issuance of digital assets. Furthermore, it will define the jurisdictions of the Commodity Futures Trading Commission, FTSE, and the Securities and Exchange Commission to govern the cryptocurrency business in the United States. There will be repercussions for Coinbase, Binance, and other companies if the cryptocurrency bill is passed into law. Congresspeople have confirmed that the summary ruling handed out by Judge Torres in July 2023 did, in fact, have a considerable impact on the design of the cryptocurrency bill. This means that this crypto law may potentially have some influence on the XRP litigation. There's a portion in the cryptocurrency law that is very similar to the decision that Judge Torres made, which stated that XRP is not a security in and of itself. Claims that an investment contract asset is a security are eliminated from consideration by the bill crypt. A digital asset that is sold or transferred or intended to be sold or transferred by an investment contract is not and does not become a security as a result of being sold or otherwise transferred by that investment contract, the document states. There was a rumor that XRP would not be considered decentralized, and a lawyer named Bill Morgan responded by saying the legislation is not retrospective. XRP has already been determined by the court to not be a security in and of itself. In addition, the Securities and Exchange Commission, on the other hand, maintains that the business is only obliged to pay civil penalties that do not exceed $10 million, but the Securities and Exchange Commission is seeking a total fine of $2 billion and a final judgment. However, it is important to note that courts have never accepted the sum that was initially demanded by a side, and the actual amount would be significantly smaller. This is quite accurate. I believe that the current ODL sales agreements offered by Ripple are based on the assumption that a permanent injunction may be granted. In the event of the worst possible outcome, this approach, which does not include the usage of XRP in USOD transactions, would most likely also be able to circumvent FIT 21 if it is approved. It was in May of this year that the local infrastructure vendor Infinite Block began assisting with the integrity of XRPL transaction validation. The news came at a time when another wave of discussion was taking place over the possibility of XRP approval in the United States. The information that has been provided is not intended to be trading advice. There is no responsibility for any investments that are made based on the information that is provided on this page. Before making any decision about investments, we strongly advise conducting independent research and consulting with a knowledgeable professional.